So I think the first thing we are going to talk about is the Chauvin verdict. And I don't want to delve too deeply into the particulars. Frankly, I think many people were absolutely glued to their screens looking at the details of the trial as they unfolded. And obviously people were tied up in many cases in rooting one way or the other for a verdict. But what I do want to talk about is the implications of what happened. That is to say, we have a conviction on 3 counts that followed very short jury deliberation in which they apparently asked no questions. And in a wider context that was frankly bizarre and quite jarring, in which Maxine Waters and the president both appeared to urge the jury toward a particular conclusion. And what I want to highlight is that this was exactly the fear that I expressed on Joe Rogan last year. My concern was that we obviously have a very dangerous and volatile situation where we've had violent riots. In the case of Portland, we've had them months on end on a nightly basis, ostensibly tied to this verdict or to this situation and what it reveals. And the problem is that we obviously had the danger of renewed violence were the verdict to have been not guilty. On the other hand, we have a standard in this country of reasonable doubt. We have the burden on the state to prove its case, and the facts of this case were highly complex. In effect, the state needed to prove that a reasonable officer, knowing what Chauvin knew, would not have acted as Chauvin did. They also needed to prove that George Floyd didn't die from other conditions that just happened to occur during the progress of this complex arrest. And in both cases, there are tremendous reasons for doubt. So, in any case, without focusing too much on the details, the question is this. Did this jury conclude what it concluded because of what was presented in court and because the arguments were persuasive where they needed to be, or did it conclude that for other reasons, such as a belief that some larger sort of justice required this answer, which, frankly, in the context of a sitting president urging a jury towards an apparent verdict and a member of Congress doing the same, this is very, very frightening. And for those who haven't thought deeply about it, the issue in question is this. The founders of the country created an environment in which the state had a tremendous burden that it needed to overcome in court for a reason, because the danger of the state not meeting such a burden left the state in an asymmetrically powerful position. So in other words, it's not that the founders weren't aware that a preponderance of the evidence, meaning the evidence said more this than that, was available, because of course that's what we have in civil trials. But in criminal trials, they wanted to hobble the state and ensure that the state had to prove something beyond a reasonable doubt in order to protect the rest of us from the state. Now, in this case, we have another factor, which is effectively mobs engaged in violence, demanding an outcome. And we have the state appearing to be persuaded by those mobs such that the executive saw fit to intervene in the decision-making process of jurors. So whether or not Chauvin is actually guilty, he's obviously been convicted, so in a technical sense he is guilty. Whether he was actually guilty and it was proven beyond a reasonable doubt in court in this venue is another question. But the hazard of allowing a situation in which public violence persuades the state to put its thumb on the scales of a trial, a criminal trial, the danger of that is impossibly great. And what is absolutely shocking to me is that people do not seem to understand that the burden of the state to prove guilt beyond a reasonable doubt to a jury of one's peers, that is the thing that protects us. This isn't about Chauvin. This is about 350 million of us who are protected from the state's aggression by that counterintuitive innovation. And my concern is that we are uninventing it.
I'm sorry. I lost you at the end. Which counterintuitive? So I was going to make a point, and I lost your logic at the very end.
Sorry about that. My point is the idea that the state should have to prove beyond a reasonable doubt is counterintuitive, right? One would expect that the state would just have to prove that your guilt is more likely than not.
Well, so this actually reminds me of what I was talking about 2 episodes ago with regard to type 1 and type 2 errors with regard to medical and surgical interventions for children who declare themselves trans.
Yep.
Right? Which kind of error do we prefer? Do we prefer to make false positives? And in the case of criminal cases, it's do we prefer to falsely convict those who are innocent, or do we prefer to falsely let off those who are actually guilty? And what the founders of this country decided is that we absolutely 100% prefer to let off some people who are guilty rather than ever put an innocent person behind bars.
Yes, exactly. They did. It is before those statistical terms ever existed.
Right.
They made quite clear their logic. And the idea was to prevent the tyranny of the state, which they were, of course, keenly aware of in light of what they had experienced with Great Britain. The twist here is that we now have the danger of the tyranny of the state under the control of the mob.
Right.
And that is a truly frightening prospect, that in effect to the extent that this was not the correct verdict, that there was reasonable doubt on the basis that, for example...
and just to be clear, I know you've said it, but when you say that this verdict may not have been correct, you are not actually saying anything about whether or not Chauvin is actually guilty. You are saying that the evidence provided in the case does not appear to meet the standard.
Right, and it is almost...
You may also be making that other point, but that is not the legal point.
I'm certainly not trying to make that point. The point I'm trying to make is that, for example, we had evidence in the case of George Floyd having ingested substantial quantities of drugs that would have put him in jeopardy in light of his heart condition. They might have put him in jeopardy absent a heart condition, but he clearly had a heart condition. He had COVID and was therefore compromised, and he was being arrested, and he was clearly panicking, which elevated his heart rate. And so the question of whether or not he died as a result of what Chauvin did, or whether or not he died as a result of the situation triggering a heart condition to cause his heart to fail, is one in which it is hard to imagine how a jury of reasonable people would not have had at least some reasonable doubt about that question. So in light of the fact that they came back... So the
question to be asked is, what other forces were in play?
Right. What other forces were in play? And in fact...
And one of the forces is blatantly obvious, which is the threat of the mob. Do damage.
The threat of the mob, or the desire to do some kind of justice above and beyond what the jury's job was, who's to say? But the problem is you cannot sacrifice an individual. You can't say, well, Chauvin is one man and, riotous mobs could kill tens or hundreds. We can't do that calculation. We cannot allow ourselves to do that calculation, because it isn't the 10 or 100 people who might be injured or killed in rioting that it's up against. It's up against the protection of the 350 million of us who are insulated from governmental tyranny by this principle. Yeah. And so, in essence, as counterintuitive as it is, that principle must stand irrespective of the cost of doing the right and legal thing in court. It was clear this was coming. This is why I said it on Joe Rogan, and I must say it was one of the most uncomfortable things I have ever said in my life in the in the unfolding emergence of the facts of this case to say, actually, as everybody was saying, this is clearly murder. And I was saying, it's not so clearly murder. This was complex. What you need is a court. And I'm concerned that a court will not be able to do its job in this case because of the larger threat of what will happen if it does.
And also, what you need is a court is not a statement that is partisan. It's not a political statement. It is a statement for democracy, regardless of where you stand, left, right, Democrat, Republican. What you need is a court in order to make such decisions is actually what stands between us and anarchy.
Anarchy and tyranny. And in this case, we may have both conspiring together. And, yes, it is absolutely unpartisan. In fact, the thing that keeps ringing in my ear is the Rawlsian veil of ignorance, right? The reason that you protect this standard, even when it will free some guilty people, right? The reason that you protect this standard is because of the justifiable fear that we should all have of a government that isn't held to this standard.
Yeah.
Right. Yeah. And, you don't know when it's going to be on your side versus on your enemy's side. And so the point is,
that's always the error of these partisan moves, isn't it?
It's always the error. And, as we watch the educational apparatus that is supposed to be upgrading all of our software come apart and engage in these petty games, I am in my mind constantly building a list of things that a proper curriculum should expose every single person to. And
as we've been doing for decades.
Right, exactly. You build a list of what should be. And one of the things is Rawlsian veil of ignorance. You need 45 minutes.
So why don't you spell it out?
The Rawlsian veil of ignorance just essentially says you shouldn't make rules that you wouldn't want to live on the wrong side of, right? You don't want to make a rule that you shouldn't be happy to face. And so that puts a limit on the kinds of rules you create, and it frankly sidelines most of this partisan garbage because you may get an advantage from doing it on Wednesday, and then on Friday you suffer the cost of it. And right, we don't want to live in that world, right? We don't want to, for example, start increasing the number of people on the court to compensate for what the last administration did, because the point is then the next administration will do it to you. And what you'll have is
we're all Supreme Court justices now.
Right. We're all right. Exactly.
That's the natural endpoint of that game.
It is. It is, because in effect, it's a race to the bottom that all the smart people know you don't want to trigger. Right. So in any case, I'm not sure where to go beyond that, except to say that I think everyone who did watch this trial, if you paid any attention at all, you saw reasonable doubt, right? It doesn't mean that you think that he wasn't in the end responsible for George Floyd's death, though a reasonable person could imagine easily that he wasn't, that George Floyd had a heart attack as a result of an elevated heart rate and drugs that he had taken, and that he died under Chauvin's knee for endogenous reasons rather than exogenous ones. But that isn't the point. The jury is instructed very specifically that the state must prove its case beyond a reasonable doubt, and they are supposed to exclude the consequences of saying one way or the other whether or not the state met that burden.